Meet Mariano Molo y Legaspi. Sadly, he died leaving no forced heirs either in ascending or descending line. He was survived by his wife, herein petitioner Juana Juan Vida de Molo, and his nephews and nieces, all surnamed Molo, who are the oppositor appellants. Mariano left two wills, the first executed on August 17, 1918, and the second executed on June 20, 1939. The second will contained a revocatory clause. Juana only found a carbon copy of the second will, and yet she filed a petition for the probate of said will. It was admitted to probate. However, upon petition filed by the herein oppositors, the order was set aside on the ground that the petitioner failed to prove its due execution. At the hearing, both parties presented their evidence. The court rendered their decision. The court denied the probate of said will because Juana failed to prove that the will was executed in accordance with law. Juana filed another petition for probate, now for the probate of the first will of the deceased. The same oppositors filed an opposition on three grounds. First, petitioner is now stopped from seeking the probate of the first will. Second, that it has not been executed in the manner required by law. And third, that the will has been subsequently revoked. The question before the court now is, can the first will be probated in view of the disallowance of the second will despite the express revocation of the former? The Supreme Court ruled yes. In the case of Sampson v. Naval, the court stated that a subsequent will containing a clause revoking a previous will, having been disallowed for the reason that it was not executed in conformity with the provisions of Section 618 of the Code of Civil Procedure as to the making of wills, cannot produce the effect of annulling the previous will, inasmuch as said revocatory clause is void. Further, when the second will was denied probate and the petitioner was asked by her attorney to look for another will, she found the duplicate of the first. There is no evidence which may directly indicate that the testator deliberately destroyed the original of the first will because of his knowledge of the revocatory clause contained in the second. What if the earlier will was voluntarily destroyed by the testator after the execution of the second will, which revoked the first? The court is of the opinion that the earlier will can still be admitted to probate under the principle of dependent relative revocation. The doctrine is usually applied where the testator cancels or destroys a will or executes an instrument intended to revoke a will with the present intention to make a new testamentary disposition as a substitute for the old, and the new disposition is not made or, if made, fails of effect per se. The failure of a new testamentary disposition upon whose validity the revocation depends prevents the revocation of the original will.